Do you see it, Jessica?
Yeah, I see it.
Okay. Now I hope I have mastered the fine art of putting us on YouTube without the audio loop, but let's just give it 1 second. Okay. All right. And you do want this reported, correct?
Yes.
Okay.
That is correct, Your Honor.
All right. Help me with the plaintiff's first name. Is it, how do you say it? Joshua?
It's pronounced Yokin, Your Honor.
Yokin. Okay. This is Yokin Schaefer versus Theodore Markos. This is 2020 cv336314. And today is October the 26th, 2020. Our courtroom is open, and our courtroom is actually staffed at this moment by a member of the Sheriff's Department. Therefore, if someone were to attend in person, we would know about it. I haven't been informed that anyone is here. I have nevertheless put these proceedings on the court's YouTube live stream link. Again, as I have explained just a little while ago to parties and counsel, that is not that link will not remain after our proceedings are over. As soon as I take us off the YouTube live stream, the record of it, as I understand it, is then gone. This is nevertheless being reported and taken down. So let's begin with some introductions, and then I will just ask a couple of more questions. I'll begin. I am Jane Barwick. For the plaintiff?
I'm Riley, Dupree, Kimbrough, Carl, and Riley, and up in Marietta, and I represent Yokin Schaefer, who is a doctor who's previously in Atlanta and has recently relocated, as I'm sure Your Honor has seen from the briefs, to Texas. Okay, and this is, are y'all in the same room? We are. We're okay. Apart, and I've got him on total mute so that you guys don't hear an echo from our computers. Okay. All right. Good to see you. Nice to meet you. Okay, Ms. Little.
Good afternoon, everyone. I am Jennifer Little for the defendant, Mr. Theodore Markos, Dr. Markos. We are not in the same location, and he is likewise on mute.
Okay, and then again, I will say that everyone, just for the record, everyone is appearing via the Zoom teleconference platform. Now, we have this on our calendar, and this is one thing I wanted to discuss with counsel. We have this on our calendar as being set down for the motion to dismiss. I do see that there was another motion filed on October the 16th, which was 10 days ago. And you're going to have to tell me, Ms. Little, whether you would like to go forward on that and if there's any objection to hearing that.
And Judge, thank you for pointing all of that out. We did speak, plaintiff's counsel and I, to give you a brief recitation of how this has occurred. Basically, the initial complaint was filed. We filed a motion to dismiss. Plaintiff amended his complaint.
Oh, I'm sorry, Mr. Riley, you represent the plaintiff.
I do, Your Honor. And so we filed.
I apologize. I'm sorry. I meant to call on plaintiff's counsel.
Oh, sorry.
No problem at all, Your Honor. We filed the emergency motion for equitable relief, trying to have Griffin placed back with plaintiff. We'd not heard from the court as to the request to add it to today's calendar. And then on Friday, Ms. Little and I spoke and reached an agreement where we would be heard by the court the afternoon of November 17th. And we had confirmed that with Ms. Cummings. But again, that was all Friday afternoon, so I don't imagine that would have made it over to your desk yet. But I believe the emergency motion for equitable relief will be coming before Your Honor on November 17th.
Okay. And then, so Ms. Little, and I apologize, would you like to argue the motion to dismiss?
Sure.
And let me just ask before, let me just start out by saying that I couldn't take this more seriously. Mm-hmm. There is a a tendency to look at the things that we all deal with. And these are two physicians, I'm assuming. So this is something that we all deal with important things. And I'm sure each and every one of us could say something we were doing this morning that was, of public emergency and so forth. We're all under a tremendous amount of pressure. So I don't take this at all lightly. You sort of got the perfect judge, which I'm certain you lawyers have discussed. With that said, I certainly want to tell everybody that I wish you could work it out, because we're going to hit a horribly hard wall pretty soon, in just a few moments from right now, where the law is concerned. And I'm not going to tell you which way that is. I'm sure your lawyers have done a great job explaining it to you. If there is any possibility for discussion, if there is any possibility for mediation, I understand one of you is in Texas now and one is in Georgia, and I respect that. But I'm sure you're also reasonable people, and I know that for a fact because you went out and you hired great lawyers, whom this court happens to think a lot of. So we're all going to get in our corners, and we're going to get our gloves on and get going here in a minute. But before everybody says things that can't be unsaid, and I'm sure maybe everybody thinks we're past the point of no return, I would like to ask you whether you would like for me to order you to mediation, which you would have to undertake in good faith. I'm sure your lawyers have talked to you about it. Let me just hear for one moment about efforts to try to resolve this. Not what was said or who offered what, but you've talked about that.
Yes, Judge. And I mean, my background is a little bit different. I'm not strictly a civil lawyer. And so when I filed our answer, I immediately emailed Mr. Riley and said, hey, introduced myself. I like to try and work things out, particularly when we're dealing with something like this. And so he and I have, I don't know, Jeff, how many conversations have we had? At least probably 6, 8 on the phone. I'm not one of these that emails folks. I like to pick up the phone and old school, get to know my opposing counsel. And he and I have discussed this case. We have discussed potential offers. But I think, unfortunately, because of the logistics with one party remaining in Texas and one being in Georgia, we have been unable to sort of reach any agreement. And Jeff,
logistics are not impossible. If Griffin were a 7-year-old boy, the logistics would not, human boy, the logistics would not be impossible.
And Your Honor, I agree with you. The logistics are not impossible. And if Griffin were a 7-year-old boy, and frankly, I think that might be part of what we're running into, is that, I personally, on a personal level, view dogs as family, not as property. I think I speak for Ms. Little as well. And then I know the two litigants here feel that way also. I think the hesitancy there is that this, in our position, is a babysitting arrangement having gone awry, and a refusal to return. So there's, absent the declaratory judgment, which Ms. Little has moved to dismiss on behalf of Dr. Markos, we're going to keep kind of being in that limbo anytime one of them just decides, hey, this is mine. I'm going to keep this. I'm going to keep Griffin this time. I bonded with him too much over this visitation stretch.
Okay, well, anything can be put into writing, including future characteristics of Griffin, but all right, let me hear your argument, Ms. Little.
Okay, Judge, and obviously I know you've read the briefs, so I will not belabor the issues. And while obviously we need to stay within the confines of the complaint, I do want to, briefly give you some background. Obviously, if defendant is unsuccessful on his motion today, Judge, what I believe you will ultimately find here is a garden variety property dispute between two men who jointly purchased and cared for a dog. And given your background in family law and your position on the Superior Court, I would imagine you have come across this issue before. And you know, as Mr. Riley and I have discussed, as our clients have discussed with us, all of us feel strongly about our pets, but under the law, they're strictly considered personal property and must be dealt with in that manner. So let me start by saying here are the facts that I do not believe will be in dispute. Plaintiff and defendant dated, and in December of 2015, they purchased Griffin, the dog. They both cared for him and provided for him financially while they were together. They broke up in 2017, and since that time, albeit some of the basis of the care is under dispute, but I don't believe either party disputes that they were both caring for and financially providing for Griffin whenever Griffin was in his custody. Meaning, when Griffin was with defendant, he was paying for Griffin and plaintiff was paying for Griffin when he was in his care. I also don't believe it will be disputed that plaintiff decided to move to Texas and that he left Griffin here with defendant on March 23rd of this year. I also do not believe it will be disputed that since that time he has not paid for or contributed to Griffin's needs. And here's where we differ, Judge. Plaintiff contends, look, I bought Griffin and I had no financial contribution from the defendant. I was the primary provider for him. And he says that after the split, that Griffin was his dog and his dog only, and that essentially he issued a right of first refusal, so to speak, that when he was out of town traveling for business, he would offer defendant the opportunity to care for Griffin. And again, simply calls himself the primary financial provider, not the sole primary financial provider. He says he has proof of that in that the dog was listed on each of his leases. He's an emotional support animal, and that he's the one that paid for the vet bills. He says that he decided to leave Griffin here while he got settled in Texas, and that he could not get back because of COVID for a little bit longer than the agreed upon time period, but that when he did get back, Griffin, was not returned to him. The defendant refused to return him. Defendant says, look, no, not at all. We purchased this dog together. In fact, I was the one that wanted the dog. I picked him out. I signed all the purchase documents myself. And look, obviously this is not why we are here today. We don't get to go into these facts, but defendant likewise has listed him on every lease, and he was also prescribed him as an emotional support animal. He is also the only one known to certain vendors like doggy daycares. And, it's our position that they had joint custody of this dog, and my client has proof of spending thousands of dollars on this dog over the course of this dog's life. And so it is our position that when the decision to move to Texas came, that the parties agreed it was in Griffin's best interest to remain here with the defendant. It is our position that plaintiff left the dog here and at some point changed his mind and came back to try and retrieve the dog. And it is our position that because of the facts and circumstances that Griffin is in fact our dog. And so obviously working with
Ms. Little, you've obviously considered that my first question, in fact, you can tell me what my first question is going to be, but my first question is going to be, given that recitation of the facts, which also appears throughout the pleadings, how is this possibly a motion to dismiss? That these are facts, are they not, that are in dispute?
Well, so
how are they anything but in dispute?
I don't believe that is not the basis of our motion to dismiss, Judge. The basis of our motion to dismiss is that equitable relief is not the proper vehicle here. We don't dispute that there's a dispute. There's clearly an ownership dispute. There is a property dispute, but equitable relief is not an available remedy to the plaintiff. And all we can do here is respond. And if we do not respond and point out the law, we will all be sitting here again later because it is reversible error to issue equitable relief when it is not warranted. And this isn't a discretionary standard. It's not a, well, I kind of want to give him equitable relief, so I think it's appropriate. The plaintiff must meet certain threshold burdens in order to be able to request equitable relief.
What's the difference between equitable relief and prejudgment attachment? What if Mr. Riley were to present evidence today that Dr. Markos was removing himself from the jurisdiction and taking Griffin with him, and or otherwise converting or doing something with the object or the subject of the complaint? Wouldn't I have the authority to issue a prejudgment attachment? And how is that different? It may be different title, but how is that different from equitable relief?
I think it comes down to what is pled, Judge. If he was able to plead certain facts and circumstances that indicated a situation where this dog was in danger or he was moving to Africa, perhaps he might be able to plead a particular complaint there that would give you the authority to do that. But all I can do in this instance is explain why this complaint, as alleged, is not proper, and it simply isn't. And so whether there would be conceivably some way he might be entitled to, sort of this relief, it still must be properly pled. And in this case, there is no situation that he has pled that entitles him to this relief, which is required under the law. And the fact of the matter is, even when seeking equitable relief and you are alleging that the person, so a lot of times we're talking about a piece of property that someone may go and sell or dispose of. And the court says, even in those circumstances, you can't do it. You still have an adequate remedy at law, and you have to pursue those avenues at law rather than in equity.
What if this, I want to challenge both of you because I've sort of had to dig out my bar review materials, challenge both of you as to why we're not talking about this in terms of trover or replevin, which I never have been able to understand or distinguish between. But I did do some research today on trover and why, what about the equitable power of the court is really different? I get titles, believe me, I understand titles, but what, let's say I agreed with you. What does that do to the case? Aren't there still theories of recovery that would allow me to return this property pending the lawsuit?
Again, Judge, that is the very basis of our argument, is he has a way to do what he wants to do. Equitable relief is not it. And we can't stand by and permit this because it would be an improper ruling. And we could just be subject to being right back here later. And so we have to point out equitable relief is not the way to go about this. And even though it's not our burden, Judge, we have basically laid out there are adequate remedies at law. We pointed to specifically trover as one example. And so that is in fact our position, is that equitable relief is not available because adequate remedies at law exist.
Well, the injunction is to quit interfering with the ownership rights of the plaintiff, essentially, right?
Well, so I guess this is where we get a little murky for purposes of this discussion involving injunctive relief specifically, because yes, there are two types, permanent and interlocutory. It was unclear to me exactly what was being requested in the complaint, because in one place he says he wants to prevent him from taking or keeping Griffin, and then in another he does ask for both. And basically because of the request now that is, has been filed for emergency equitable relief for purposes of today's hearing, I was prepared to discuss specifically injunctive relief as a whole. Certainly, if the court wants to go into the sort of deeper analysis of interlocutory relief or interlocutory injunction, I'm prepared to do so, but I don't believe either is appropriate in this case because there's a threshold burden for both interlocutory and permanent, and that is that no other adequate remedy at law exists. And so defendant went into detail in his initial motion to dismiss to sort of point out, although we don't know what plaintiff could potentially allege. We don't know what is in plaintiff's mind, but we did sort of look at it and say, hey, this kind of sounds like a breach of contract or a trover action. And therefore, if those two actions at law exist, you cannot proceed via injunctive relief. And so that is our point, Judge, as we come here today. And again, we can't do anything other than respond here.
Anything further?
I mean, I guess, what we're dealing with here is a complaint that requests 3 different forms of equitable relief. And so rather than just sort of not addressing them, I guess I should just very briefly touch upon them. Okay, so I think we've covered the interlocutory already, the injunctive relief already. Both interlocutory and permanent have a threshold burden, which is that, no other adequate remedy at law can exist. And again, Judge, this is not discretionary. It is a situation where if an adequate remedy at law exists, injunctive relief is not proper. And for the reasons that the court has already sort of hinted at, an adequate remedy at law does exist. And so injunctive relief, the count involving injunctive relief needs to be dismissed. To sort of back up briefly, I do want to point out that equitable relief is not your go-to, okay? This is not the first line of attack. Someone basically has to establish why they are entitled to it. And each of the 3 forms has slightly different requirements. And the one that I was going to sort of attack first is declaratory judgment, because I think that one has sort of the strictest rules and sort of the easiest, and is therefore the easiest to dispense of today. And I don't know if you want to hear argument on this, Judge, or if you've already made up your mind, but okay.
That's what argument's for.
Okay. So it's our opinion, based upon the case law, that he is not entitled to declaratory judgment in this case. And the reason is pretty specific, okay? Declaratory judgment is warranted in very specific circumstances. This is quite possibly sort of the most restrictive requirements. And it is only warranted when the plaintiff can say, I must take some action in the future. There's a decision that I need to make about this action, and I'm confused. Judge, I don't know what decision I should make, and that I may harm myself with this action that I must take. And so I need you, Judge, to declare something so that I know what to do, so that I don't harm myself in the future. And that is a very clear requirement, and it has been held that it is an essential ingredient. And not only that they just have to meet this at some point, it must be pled, Judge. It must have been pled in the complaint. And the failure to be able to plead this future conduct about which the plaintiff is concerned about his own decision that he must make absolutely has to be pled. And if it isn't, a declaratory judgment is improper. And again, there's no sort of overarching standard where, well, if we really like the litigant, or if we really kind of feel like he's deserving of this, you're allowed to do it. No, this is an absolute requirement he must meet. And so when we argue that in response, plaintiff amended his complaint and alleged future conduct on the part of defendant that may or may not happen. Essentially, he said, look, Judge, I'm concerned about future conduct the defendant might take in the future. And I need you to declare me the legal owner, okay? And that is just simply improper on its face. The future conduct must be that of the petitioner. In order to ask the court for a declaratory judgment, You have to be concerned about your own future conduct. Judge, I don't know what to do, and I have to make this decision in the future. It must be my own conduct. Also, the conduct cannot be a possibility, okay? It has to be something that must occur. Otherwise, we could really conceivably ask for declaratory judgment on any grounds, because we could say someone else might do something in the future, and therefore I need you to make a decision, Judge. That is simply an improper basis for declaratory judgment. When he amended the complaint in this manner, I wanted to sort of go back and find a case, sort of on this direct position, because I cited cases before that gave good examples of declaratory judgments in the context of what is typically, seen, which is sort of an insurance coverage issue. And so when I started doing some research about possible future contingencies, I actually ran up against a case that I was coincidentally directly involved in. When I was a baby assistant district attorney in DeKalb County, one of my first days in court, they sent me over to handle preliminary hearings. And the judges were requiring me to have non-hearsay testimony in order to bind a case over. And I, as a young attorney, thought, well, the standard is the same for a warrant as it is for this hearing. And so I went to my boss and said, boss, I'm just a little confused, because here's what they're requiring in court, and it doesn't seem appropriate under the law. And ultimately, the DeKalb district attorney ultimately had to sue the magistrate court. And so in that lawsuit, she asked for declaratory judgment. And I bring this case forward, Judge, because I think it shows two things. It shows a good example of an appropriate declaratory judgment, and it also shows when a declaratory judgment based upon a possible future contingency will be struck down. And so in that case, the DA was faced with a decision she had to make, okay? There were upcoming hearings every single day. Every single day, she had to make a decision as to whether to call a victim, a live witness, what evidence she had to present, okay? That is a decision she had to make as to an immediate future event that was taking place. The decision, she could, and also that decision could negatively harm her, okay? If she didn't present the right evidence, the cases might not get bound over. And so it's not only that you have to take this decision, that it's you that has to take it, but also your interests may be harmed, okay? And so she went to the court and she said, I needed a declaration. And the court upheld the first two declarations, which were the appropriate, number one, the appropriate evidentiary standard at a preliminary hearing. And then number two, the court declared that the MAG court had to accept hearsay testimony at a prelim, okay? So the higher court said, yep, good declaratory judgment, right? She didn't know what to do. She needed advice and counsel as to some decision she had to make, and it was necessary to protect her interests. The court, because there was quite a bit of history to this litigation, the court, in making that ruling, took it one step further, Judge, and they said, and oh, by the way, Magistrate Court, if you do not follow these first two declarations, if, being the key word, if you do not follow these two declarations, you can be subject to a complaint to the JQC. On appeal, the higher court said, look, first two, great. Third has to be struck down because it's based upon a possible future contingency. And that is simply not appropriate for a declaratory judgment. In this case, there is no future action that has to take place. The dispute has already closed, so to speak. We don't have a ruling on the dispute yet, but there are no future actions that have to take place. Either plaintiff owns Griffin and we have got him, so to speak, or we own him, or they jointly own him, but there are no actions that need to take place to decide that other than a proper cause of action being filed, okay? And so there is nothing that the plaintiff can point to in terms of his future conduct that he needs guidance on. And for those reasons, a declaration is not appropriate. And one cannot seek a declaration as to the ultimate issue. And that's kind of what's being done here. You know, we have a property dispute, and instead of using the proper channels, he's asking for you to look into the facts and circumstances and declare an owner. And that is simply not the right vehicle to do so. And again, we have to step back and point out the law because we don't want to prolong this any longer. And that is the law. And then finally, what we're looking at is specific performance, Judge. And so in response to our sort of motion to dismiss where we said, hey, this sounds like a breach of contract or a trover action, if anything, he did amend his complaint and request specific performance. And the issue here, though, is that he didn't properly plead a breach of contract case. There are certain requirements that you must meet in order to meet a threshold burden in order to plead a breach of contract case. Now, those that burden, I cited cases to support this, Judge. I'm not going to belabor the point, but for a proper breach of contract claim to move forward past a motion to dismiss, it must allege with certainty the material terms of the contract, particularly when, as here, they're asking for specific performance. I mean, it just makes sense that if you're asking a court to order performance with a contract, you have to be very specific about what the terms of the contract were, because you've got to tell someone how to perform according to it. And so here, for instance, consideration was never mentioned. The particulars of how or when this contract was to be performed were not alleged. And so as an initial matter, the threshold burden that's required for purposes of pleading a breach of contract case was not met. Not to mention, it's not even clear if that is what is alleged, because the word contract was not even used in the complaint at all. He merely alleges that there was an agreement for him to babysit. Which sort of brings me to my next point, which is the black letter law of specific performance kind of gives us a pretty good indication of why it's not appropriate here. And the black letter law says, look, specific performance is not okay for a voluntary agreement or a gratuitous promise. And that's what we have here. Even based on the allegations in the complaint, plaintiff alleges that we, the defendant, agreed to babysit his dog while he was out of town, and that then we didn't give the dog back. And so that is a gratuitous promise or a voluntary agreement. There was nothing that, we paid for the dog ourselves while the dog was here. Plaintiff did not give us anything in return. This was a promise to watch someone's animal. No different than, as I argued in my motion, if I agree to watch my sister's child and then I decided not to later, that is merely a voluntary agreement or a gratuitous promise. It is not a contract, and therefore specific performance cannot be decreed. It is not appropriate. We believe, as an initial matter, specific performance is not appropriate simply because of those two things. It wasn't, it didn't rise to the level of a contract, and he didn't allege a contract to begin with in the complaint, and therefore we believe specific performance must be, this count must be dismissed. So there are some more specifics, and I think here is where it gets a little bit more into some of the emotional issues as it relates to the dog. Our position, very quickly, Judge, is simply this. Again, as in with all the equitable relief, forms of equitable relief, this is not discretionary. These burdens must be met by the plaintiff. It is not something that we can sort of say, yeah, he didn't, but, okay, he must meet these. He didn't properly plead a breach of contract. He only alleged a voluntary agreement. An adequate remedy at law does exist. And this is yet again another thing that he must establish. And defendant pointed to a specific case where someone was seeking to decree specific performance of personal property, and they said you did not establish that an adequate remedy at law exists. And because you could not establish that, we have to dismiss your case for specific performance. Additionally, the only way to get specific performance, there's a heightened duty in order to get specific performance over monetary damages. And what one must establish, they must prove that monetary damages are inadequate compensation. On its face, I understand plaintiff's position here. Our position is, though, that under the law, monetary damages are sufficient. They are adequate compensation, and that is based upon the Parking Hound decision, which specifically held that sentimental value is not something that you can recover for in a court of law. It said,
Hound case, which we all read when it came out. We all read it with interest for the same reason we're all interested in what happens today. But the premise of the barking hound case was the value of the dog after it died.
Mhm.
There wasn't a question of bailment or the veterinarian keeping the dog beyond beyond the bailment period. That was just looking at it afterwards, determining whether you could establish some sort of wrongful death action. It wasn't who gets to keep the dog while the dog's alive.
Absolutely not, Judge, and we wouldn't suggest that at all. In fact, the only thing that we're suggesting is that if plaintiff seeks to establish that monetary damages are inadequate compensation, it flies in the face of the barking hound decision that sentimental value is not appropriate measure of damages. So the point is, if plaintiff has to establish that monetary damages are inadequate compensation, and his basis for claiming that it's inadequate compensation is sentimental value, but that the court has already said you're not entitled to that sentimental value, it doesn't seem to be a consistent, like a consistent statement, I guess is what I'm saying. I find it hard for the plaintiff to establish that damages, which he cannot get in a court of law, because money can't possibly compensate him for them, monetary damages are inadequate. Perhaps I'm not articulating this well, but I guess what he's saying is, look, monetary damages are inadequate because the sentimental value I feel for my dog, you can't possibly compensate me for that. But the court has said you're not allowed to be compensated for that. So it doesn't make sense that you could base your position that monetary damages are inadequate on something that the court has already said you're not even allowed to ask for money for. But that said, I understand the position, the feeling. Obviously, we all do. And so even if the court, agrees with that premise, you still have the general prohibition of decreeing personal property. And again, if plaintiff has arguments here that are close to getting it done, I think these are his two best arguments, are that monetary damages are inadequate, and that, this unique relationship should rise to the level of an exception to the general, rule that personal property will not be decreed. Okay, I understand that is where he gains some traction. We believe that under the law, because the court has said sentimental value is not something that you're allowed to request monetary damages for, that in and of itself suggests that, they would not be inadequate, because otherwise, why not allow for sentimental value? But even beyond that, Judge, we still have the general prohibition of decreeing personal property. I was not able to find a single case where the court allowed the decree of specific performance for personal property. But there is an exception if the plaintiff can state a reason and good conscience and equity to take it out of that general rule. And it appears as though, based upon some of his briefs, that plaintiff seeks to argue that this unique bond that we all, acknowledge, is the good reason, or the reason in good conscience and equity to remove it from this general prohibition. And so he argues that the property is alive, it is unique, and that it has a limited lifespan. And plaintiff or defendant, well, again, we understand the emotional attachment here. We understand the argument. And quite frankly, emotionally speaking, we don't disagree with it. We both obviously care about this dog, but we are constrained by the laws. And the law says, unfortunately, Griffin is simply a piece of chattel, and he is not unique. He is capable of assessing monetary damages. He is capable of these things. And as harsh as that is for us to accept as pet owners, we need to turn to the legislature on that. And so it is the law. And so if we were to extrapolate and create a pet exception, which, Judge, here is where you have discretion. You can absolutely say, I believe there should be a pet exception. And so our only argument here is that the courts have not consistently supported that idea. They have in fact gone the opposite way. They have said, no, unfortunately, this is simply personal property. And it needs to be treated that way. And so our argument is, where would it end? I mean, we could conceivably be in court based upon, as we argued, plants, snakes, hermit crabs. I just bought my kids a hermit crab at the beach, and I'm learning all about the lifespan of a hermit crab and how to care for it. Now, I care about this hermit crab at this point, especially after the money I've spent. Who knew these were so hard to keep alive? But unfortunately, how far can we take it? And so, but I do believe, Judge, look, we're all here. We all get the issues. I do believe here is where you have, some room. Would you see that monetary damages are inadequate or that there should be a pet exception? That's for you to determine. But ultimately, legally speaking, it is our position that regardless of whether you do those two things, we still can't get there because he did not plead a breach of contract. It was not a contract to begin with. And again, an adequate remedy at law exists. And we can't properly plead his complaint. We've done everything we can, which is simply defend and say, we can't just sit by because we don't want to be back here after an appeal. And this is not the way we have to deal with these claims. Thank you, Judge.
Okay, thank you, Ms. Little. I appreciate it. Mr. Riley?
Thank you, Judge. Just briefly, I think Ms. Little said this at the front end, but then it launched into kind of a factual dispute that felt more like a motion for summary judgment. We're here on a 12B6. The court has to take the allegations in the complaint as true. It has been alleged, and we have documentary evidence that we feel supports it, and we attach it to our emergency motion for equitable relief, but it has been alleged that Dr. Markos stole the dog from Dr. Schaefer. And all the allegations in the complaint are what the court is analyzing this motion to dismiss on. Is, do those allegations, when taken as true, when taken most favorably to the plaintiff, the non-moving party, do they set forth any set of facts, any sort of claims under which relief can be granted? And you'll notice it was mentioned by Ms. Little that no money has been requested by plaintiff. He is looking strictly for equitable remedies here. He wants Griffin back. He doesn't want the $1,500, whatever they paid for him. He doesn't want his veterinary bills that he paid up until the date he was taken from him. He is simply looking for Griffin to come back. And there was a comment made by Ms. Little that this is not discretionary to the court. The court has no discretion when it comes to equitable remedies. The law is quite the opposite with respect to this court's authority on equitable remedies. The law, as stated in Barngrover versus City of Columbus in 292 Georgia 486, says that this court has broad discretion to fashion an equitable remedy based on the exigencies of the case. And Allied Productions Inc. versus Peterson, 233 Georgia 266, builds on that to say that those equitable remedies and equitable authority by the court can be exercised in the court's discretion before a final judgment has even been reached. And so this idea that the court's hands are completely tied and has no discretion to offer an equitable remedy here is not consistent with the jurisprudence that's coming from the Supreme Court of Georgia. And Your Honor, I think you hit the nail on the head with the Barkinghound Village and the distinguishing there. In Barkinghound Village, they were proceeding for a wrongful death claim. They were not proceeding to recover the dog. In determining that sentimental value, to use Ms. Little's term, is not something that can be recovered, the court said no wrongful death action could be maintained. And maybe I interpret that differently, but what I interpreted that as was that I cannot use sentimental value as an element of damages. I cannot say we paid $1,000 for the dog, we put $5,000 into his care, and then we have $100,000 worth of sentimental feelings on top of it. I did not take that to mean that the court has to disregard the character and the nature of every piece of property that comes before it, even if there is sentimental value. For example, if I'm running down the street and I'm wearing a watch from my grandfather that's worth $20, but it's been passed down generation to generation, and it gets ripped off my arm and stolen from me, and I go to court, I'm going to want the watch back. That $20 isn't going to do anything for me. Now, the courts have discretion to give me that watch back. They don't have discretion to say, because of that sentimental value, that watch was worth $25,000 and you get it back. And just as a thought exercise, in that Barkinghound Village case, what if that dog was still alive? And what if the family came home from vacation and went to Barkinghound Village, just as Dr. Schaefer came home from Texas and went to try and get Griffin from Dr. Markos, but Barkinghound Village reacted the way Dr. Markos did. So we've been caring for the dog for too long. We've become attached to it. We're not giving it back. Do we think the Supreme Court of Georgia would have said the sole remedy for that family was the value of the dog? It's a hypothetical, we'll never know, but I think common sense dictates that the Supreme Court of Georgia would not have said that. We're not dealing with an analogous situation. Griffin is still alive. This court has an opportunity to restore the relationship between Griffin and his rightful owner. And we're here today on the complaint. We do have extensive documentary evidence, some of which is attached to the motion, emergency motion for equitable relief, that shows the understanding between the parties in written communications, that shows that Dr. Schaefer was Griffin's owner, that shows that Griffin was Dr. Schaefer's personal property. Now, Dr. Schaefer is not seeking any financial recovery for the sentimental value of Griffin. He's seeking the restoration of a relationship. He's asking this court to use its broad discretion based upon the exigencies of this specific case to restore the relationship between Griffin and Dr. Schaefer.
He is asking for attorney's fees, Mr. Riley.
Well, I will speak for Dr. Schaefer that he would waive the claim for attorney's fees if he were to get Griffin back.
Absolutely.
We're not bargaining.
Yeah. And I know you and I don't mediate, Judge, but I would just letting you know that that is where it's at. And I apologize for that oversight. There have been attorney's fees requested, but he's not asking for the value of the dog. He's not asking for the care of the dog that has been put into the Griffin to this point. Now, does Georgia law recognize equitable relief for certain types of personal property? Absolutely. It recognizes equitable relief for real property as well. I gave the example of a family heirloom being passed down. You cannot go to court and get $1 million because your feelings were hurt when the heirloom was stolen. You can go to court and have it ordered that the heirloom be returned to you based on the court's broad discretion. That's what's happening here. We're not saying that Dr. Schaefer's relationship with Griffin was so great that he needs $500,000, or that he needs $1 million. He just wants Griffin back. Now, I'm in a unique position. I work with someone who has been doing this for a very, very long time. My partner, Hilton Dupree, has been practicing for over 50 years now. We joke with him that he's kind of like the guy from that farmer's insurance commercial where, they say, oh, you got a problem? We've seen it. And that's how it feels with Hilton. So I went to him to talk to him about this case because I would have been foolish not to use that resource. And I asked Mr. Dupree about it, and he kind of shook his head. He said, I've never come across anything like this. But he told me a story about his hunting dog, Gus, who's a yellow lab. And I've met Gus a few times. I don't know much about hunting, but I guess Gus has done all these shows, has showed very well. And someone approached Mr. Dupree at one of these shows. And he said, how much have you put into that dog to this point? So Mr. Dupree told him, and he said, no, I'm asking for a dollar value. So Mr. Dupree gave him a rough estimate. And he said, I'll double it if you'll give me the dog. And Mr. Dupree said, no, I don't need the dog. I don't need the money. And he kept raising his price until Mr. Dupree finally said, there's no amount of money. This is my dog. We've forged a relationship up to this point. I'm looking forward to what's going to happen in the future. I'm enjoying what we're doing. This isn't about money. This isn't a monetary thing. And I kind of laughed, and he asked me, why are you laughing? I said, because you said the same thing the Supreme Court of Georgia said, that the relationship between a pet and its owner is beyond legal measure. And I think another way to say that is that there would be no adequate remedy at law for having a pet taken from its owner. That is exactly what is alleged has happened in this case. And there is no remedy that can rectify that short of this court intervening and issuing injunctive equitable relief. And the specific performance, the argument that it has not been pled to the point of a contract, there was an offer by Dr. Markos to babysit. There was an acceptance by Dr. Schaefer, and there was reliance on that. Clearly, Dr. Markos has not turned around and returned Griffin. Clearly, Dr. Markos derives some value from having Griffin. There's your consideration piece. And Georgia is a notice pleading state. You do not have to say specifically, these are the claims, X, Y, Z. You just have to lay it out so that the other side is on notice of what is being pled. And I think just by Ms. Little's analysis of our complaint, where she identified the offer, she identified the acceptance, she noted that the word consideration wasn't mentioned, but the inherent value that Dr. Markos clearly finds in having the dog, I think there's been plenty pled there to show that there is grounds for specific performance here. And this is a particularly unique case. But again, what this all boils down to, Judge, is whether Dr. Schaefer has asserted a claim based upon the allegations in the complaint under which the court could grant relief. And as noted, this court has broad discretion to exercise an equitable remedy based upon the exigencies of the case. And we're asking this court in our complaint, and we will be asking again, should we get to this point in the emergency motion for equitable relief, to fashion such a remedy and return Griffin to Dr. Schaefer. Thank you.
Thank you. Any response, Ms. Little?
Very, very briefly, Judge. I was simply looking through the cases that I cited regarding the burden as it relates to pleading the breach of contract claim. And there was a case that did say that it's not simply offer acceptance. You do have to allege consideration, and even on a motion to dismiss, it is subject to demurrer when you do not allege all the material terms, one of which in that case was simply value. That would be the Johns versus Nix case. It is cited in my motion. In that case, they said that the demurrer must be upheld because they did not allege the value. The value must have been pled. I believe that's the one. I mean, I could, if you want me to specifically refer to some specific cases, Judge, but those cases were cited, and so you have those before the court. I do want to back up, because if I misstated anything, I want to be very clear. The power to issue equitable relief is absolutely discretionary within the court's power. Okay, I'm not suggesting that you can't just issue declaratory relief. What I am suggesting is that the requirements that must be met are not discretionary. The cases have consistently held that yes, you as a judge, you can issue equitable relief or you can deny equitable relief. That is in your discretion, but that is only after the threshold showing of certain requirements. And those are the requirements that I was speaking about. And that is where the discretion is not allowed. And that is why cases issuing injunctive relief, cases issuing declaratory judgment, and cases issuing specific performance, all of which have been reversed. And the reason is because it's not entirely discretionary. Those burdens must be met. Once those are met, it's absolutely within your discretion. And so I just wanted to be clear that that is what I meant. And, you know, again, I think there is an assumption, there is a jump that plaintiff's counsel is making when he argues things like, well, if we went to Barking Hound and asked for the dog back, the court wouldn't say we couldn't do that. And again, defendant has never suggested that the relief he requests, meaning the return of Griffin, is impossible to get. In fact, what we are suggesting is just the opposite. It is in fact you are able to get the return of Griffin through an action at law. You are able to seek the return of that dog via an action at law. And because of that, the relief requested via equitable relief is not available. And I just want to make that point clear, because it seems like plaintiff's counsel believes what we're saying is you're only entitled to monetary damages, and that is not our position. Thank you, Judge.
Okay, thank y'all very much. As I said, I don't there's nothing insignificant about this case. And I do take it very seriously. At this point, I'm going to deny the motion to dismiss. I am going to reserve ruling on the declaratory judgment. You may be right there. I'm not, I think we need a little bit more development of the facts. And I think Mr. Riley makes a decent point at the 12B6 character of these proceedings. So I'm not going to dismiss. There may be something to the declaratory judgment. There may be something to the specific performance, but I think with regard to the declaratory judgment, I'm specifically reserving ruling on that. We're going to move forward to the next phase. No idea what's going to happen there, but we will have the hearing on November the 17th. If you want to, since that, I mean, I don't, yeah, there are some, are there affidavits?
Not yet, Judge.
Not
Okay.
yet. There will be.
I didn't think so, but I did think I'd seen, maybe I saw some emails or text as just an attachment to something, but so I didn't think we were at the fact that those had been developed yet. So the point of that is that if you do have the need to present witnesses, you need to think about how that's going to be done. I'm happy to not do it. I'm happy to let the parties testify if they want to testify. I'm happy to not let the parties testify if they don't want to testify. But we do need to decide ahead of time how we're going to do that, because of the times that I've had live witnesses on Zoom, which may be in a contradiction in terms, but the times it's gone fine. I mean, there have not been any subtleties that anyone missed in face-to-face. But if you do want to come to the courthouse, any or all of you, please let us know ahead of time, because we have all kinds of different technology we can employ to have some people via Zoom and some people in person. So just let us know that before the 17th. We are going to move on to the next step. And I don't know what's going to happen there. But,
Judge, are you going to issue a written order? And if so, when can we expect that? I just need to sort of go through that with my client.
Mr. Riley prepares a draft of it and circulates it to all of us.
Okay.
I will have it circulated by the end of the day tomorrow.
It's nothing profound. I mean, I'm just saying that at this point, I don't think we haven't met the standard for a motion to dismiss. And it doesn't need a lot of citation. I thought Ms. Little made an excellent point on the declaratory judgment, but I haven't ruled on that.
All right. Thank you, Judge.
Okay, so if you'll circulate that, I'll take a look at it, get it entered, and then I'll see y'all hopefully, hopefully not. Hopefully you're at the point now where you kind of seen, nah, court doesn't work either. That's not really the place to get your problem solved. If you're looking at a jury trial, and I'm not being facetious at all, Griffin is going to be getting much, 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 much older. Because I've got personally about 300 criminal defendants whose trial will take precedence.
Understood, Your Honor.
But I'm happy that, I'm happy to, we'll see where it goes on the interlocutory injunction. I wish y'all would talk. I know how you feel.
Yeah, we all do.
Yep.
And I'd love to be Solomon and say, okay, send Griffin down here and I'll cut him in half. and just to see who says, no, that's okay. We all know that story, but I do think, there's a lot of analogy, and then unfortunately none at all. And remember, I worked for somebody who said, tough cases make bad law. So at the end of the day, I guess I'll do my job.
Thank you, Judge.
Talk.
Thank
Thank
you, Judge.
y'all.
We will. Okay,
Thank you.
take care.
Nice meeting everybody.
Yeah, nice to meet you too.
Great to meet everyone. Take care.
Thank you, Judge.
Okay, thank you.
Jeff, do you want to stay on?
Then I can just leave meeting and let y'all, I'm gonna leave.
He left anyway, so I'll just call him. We
Okay.
talk constantly.
Okay.
Bye, Judge. Take care. Thanks.